People of the state of Michigan versus Benjamin Macario Martinez, 237407 ST, 226707 ST, and 162435 FY. Concerning the matters then we were set over from last time. Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the two files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the two open charges, Mr. Martinez, and you're proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
The court begins proceedings involving multiple cases against Benjamin Macario Martinez. Judge and counsel confirm that Mr. Martinez has chosen to represent himself rather than use a court-appointed attorney. The judge reminds him that self-representation comes with challenges, especially when facing trained legal professionals. Mr. Martinez insists on proceeding without a lawyer. The judge questions his readiness and notes the disadvantages of representing oneself in complex legal matters. The court prepares to address both the outstanding charges in sentencing for past contempt cases. This sets the stage for a hearing filled with procedural confusion and frequent legal misinterpretations.
Concerning the two files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or inadequate law books. They're old. I only got an hour and a half.
Mr. Martinez requests that the charges against him be dismissed under the Speedy Trial Act, claiming his rights were violated. He also asserts that he did not receive sufficient access to legal materials while incarcerated, which impacted his ability to prepare. The court listens respectfully but questions whether these claims align with procedural realities. Mr. Martinez attempts to read legal motions aloud, citing free speech and his civil rights. While the court acknowledges his right to self-representation, the judge notes the legal standards that must still be followed. This moment reveals the tension between asserting rights and understanding how to properly execute them in court.
I only know some rules for an hour and a half of studying, so out of my freedom of speech and the rules of professional conduct, I'd like to read my motions.
All right, go right ahead.
Before we waste the time and the money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. not enough time to study even after a motion, or the judge throughout plea not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own.
The defendant argues for a dismissal based on not receiving adequate preparation time. However, he simultaneously insists on a speedy trial. The judge points out the contradiction. Claiming a right to a speedy trial while also asking for more preparation time requires legal balance. Mr. Martinez then alleges bias from the court and excessive bond conditions. The court responds by emphasizing that bond decisions were already reviewed and amended, and that previous no-shows influenced these rulings. The judge reiterates that showing up for scheduled proceedings is critical. The courtroom begins to see a pattern of conflicting arguments from the defendant,
which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court. And for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out. And when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on. And I'd like to have my trial by jurors, and these are the few offhand as to why most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion, prosecutors rule 3.8, didn't take action or all actions, making sure my rights were protected, and rules 4.3, if they know the law and what I'm saying, these are US Supreme Court, Michigan rules, and 30 days minimum for US Supreme Court 3161-C2 Dismissal Speedy Trial Act 3162 and 3164 1974 18 and discipline of all attorney 3161, knowing I'd never be able to proceed without justification. Rules 3.2, repugnant or imprudent prejudicing impartial trial, miscarriage. Also People versus Lehman, stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear.
Mr. Martinez continues listing grievances, referencing U.S. Supreme Court cases and federal codes like the Speedy Trial Act. He argues that his civil rights were infringed due to insufficient library access, improper legal support, and alleged bias. The court remains patient but clarifies that legal references alone do not justify dismissal unless directly applicable. The judge notes that Mr. Martinez has not followed through on several key responsibilities, including court appearances. While the defendant insists he was unaware of certain court dates, transcripts show otherwise. The court considers whether these claims are delaying tactics or rooted in misunderstanding.
And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
Your Honor, that's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like there's no way that will have 30 days to be able to study and defend myself from the time of this trial. And it states that as a federal law that, and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that. And oh, you didn't want that either. So then we went through the hearings and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws stating that you cannot imprison somebody for fines being.
The prosecution responds, stating that one of the cases was recently set for trial and the other involved a no-show by the defendant. Mr. Martinez's arguments about inadequate legal access are countered with the reminder that he could request a public defender at any time. The judge highlights that prior communications from Mr. Martinez made no mention of the Speedy Trial Act or other rights violations. The court concludes that the legal record does not support dismissal. The hearing moves forward with the judge preparing to sentence Mr. Martinez on contempt charges from past failures to appear.
And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything you wish.
You gave me bogus
Mr.
information.
Martinez.
You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435 FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707 ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. In regard to your outstanding cases, the 23-7407 ST, we will set that for trial on July 10th. That'll be all-day trial. That one will come first. And we will set the 22-6707 ST trial for just for a call that day. But we're going to try the newer one first. The older one, he's already failed to appear on it twice. I'm making the following findings in respect concerning Michigan Court Rule 6.004 speedy trial. In regard to the matter concerning Mr. Martinez, bond is set at 1,000 personal recognizance. Actually, it's set at 1,000 personal recognizance in 23-7407 ST. I don't think I'm going to set that one first then. In regard to the 22-6707, he has a bond on the failures to appear. He's already been sentenced on those. He's serving time on them now. The underlying bond on the driving charge is, can you pull it up on JIS, please?
On to the failures or for the underlying is 2,500 cash or 10%.
All right, we'll set that one for trial first then.
Which one?
The 22-6707 ST. The newer one has a PR bond on it. So there's no requirements for time on that.
Okay, so it'll be a firm trial date on
July 10th.
707.
Yes, on July 10th. And concerning the matter then, in regard to the court rule, Mr. Martinez has been incarcerated since his arrest on May 25th on all of these matters that were outstanding. The trial is set for July the 10th, which is beyond 28 days. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, and he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules, there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings, should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new trial along.
The court reminds Mr. Martinez that multiple contempt charges were previously addressed. 2 were dismissed if he entered pleas, but he declined. As a result, he was found guilty of 4 counts of contempt for not appearing in court and for failing to pay long-standing fines. The judge clarifies the difference between unpaid fines and court-ordered sanctions. Non-compliance with the latter can result in jail time. Mr. Martinez challenges this interpretation, but the judge firmly reiterates the court's authority. The sentencing is announced, including jail time and credited days for each count.
And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez, it's on you. In the meantime, an appeal to circuit court may be taken within 21 days from the date of your sentence, or as permitted pursuant to Michigan Court Rule 6.625B, if the sentence includes incarceration, and if you wish to file an appeal but are financially unable to do so, MIDC will appoint a lawyer for you if that request is made within 14 days after your sentencing. In regard to the issue of trial, any requests for jury instructions and whatnot. The pretrial order was released. I sent out a pretrial order last year. Those 10 deadlines remain in place. Mr. Martinez, we'll see you for trial July the 10th.
Yep.
Anything changes in the meantime, you know what to do. Yes, the balance due remains outstanding, payable commencing 30 days after his release from jail and every 30th day thereafter. And that's 100 a month on that outstanding 2016 case. All right, thanks to the jail. That'll be it on these files.
With contempt sentencing complete, the court sets firm trial dates for Mr. Martinez's remaining cases. The judge prioritizes the most recent case and confirms that older cases have already been delayed due to prior no-shows. Mr. Martinez is granted a personal recognizance bond on one case, meaning he will not have to pay to be released, but only if he appears in court as ordered. The court emphasizes that continued noncompliance could lead to stricter measures. These trial dates mark the court's effort to move forward while offering Mr. Martinez a final opportunity to meet legal expectations.